Good afternoon, everybody, and welcome once again to another session of Lunch and Learn. Today, we will be discussing how maintenance orders are enforced when the respondents are in arrears. And this is something that inevitably happens during the maintenance process. That respondents become in default, they fall into default, and they don't make payments on their maintenance. And what are the remedies? What are the tools that the complainants then could use in order to enforce those maintenance agreements? So what we will be discussing today is how we'll just give you a brief overview of the remedies that are available. We'll have a brief discussion on three types of processes that is governed by Chapter 5 of the Maintenance Act that makes provision for certain remedies when the respondent are in arrears or is in arrears with his maintenance payments. And those are the warrants of execution, the attachment orders, as well as emolument attachment orders, or commonly known as garnishee orders. Now, we will, in the next three webinars, we will discuss in depth the warrants of execution, the attachment orders, as well as the emolument attachment orders. So we will be discussing that and unpack that in greater detail in the next three webinars, or the Lunch and Learn webinars. We'll also be discussing in this webinar, we will be discussing what is meant by sequestration as a different form of enforcement of a maintenance order, if you can have someone being sequestrated. And we'll also explain it, just have a brief explanation on how criminal proceedings work, because there is a criminality. If someone does not pay his maintenance obligation, then he could be sent to jail for up to a period of 3 years. We'll be discussing that. We'll also be addressing the issue of when exactly is a person in arrears. What is the time frame allowed for by the Maintenance Act that needs to elapse before you can actually go to the maintenance officer and lay a complaint for arrear maintenance? And then we will be discussing the process on how you report those arrear maintenance, as well as a short discussion on the defenses that could be used by the respondents of not paying maintenance when they are in arrears. Just some logistics, as we all know by now, that by the time that you've registered, all the registrants, welcome to all those that registered, those would all have received a separate email with a link that they can watch this webinar on. In that link, you would also find a web page containing some pre-reading material. There's no pre-reading material for this webinar. You'll have the link of the webinar itself, and then very importantly, the resource and templates tab. Now, that is a tab that could be utilized, and we'll download all the documents that we are referring to in that folder, specifically the J forms that we will be discussing for that you need to file for maintenance. We'll put that in that folder, as well as some of the case law that we will be referring to. We will also download in that, or put in that folder for you to download copies of the slides, as well as the complete handout that is available. And those are all available for the people that registered for this webinar on www.lunchandlearn.org.za. But without further ado, I think we should continue, and then just let's start off with some general comments on the overview of the remedies that is available for respondents. Now, one should very clearly note that we will be addressing in this webinar, we will be addressing the event where both parties are still in South Africa. Both parties, the complainant and the respondent is both in South Africa. They're both located in South Africa, and not where the case might be where one party is overseas or outside the Republic of South Africa. Now, any maintenance matter, either a new application or even an enforcement of a maintenance order could be done with parties outside the borders of South Africa, but that is governed by a different act, and that is governed by the Reciprocal Enforcement of Maintenance Orders Act of 1963. Now, this is a specialized field of maintenance collection or maintenance applications. It is done by the maintenance courts. They do know how to do that, or they are supposed to know how to do that. But like I said, it's a little bit more complicated for the most people to understand, because you work with treaties and you work with a whole different process where you have to work through the Department of Home Affairs and then to serve the documents in abroad. So that is a completely different process, and we will be addressing at least 2 webinars dealing specifically with these type of REMA applications. Advocate Dion Reuters, the senior maintenance prosecutor from Cape Town, from the National Prosecuting Authority, he will be doing at least two webinars on all the REMA applications, because there's a great need for that. And I already received some emails of participants and registrants requesting details on that. But for purposes of this webinar, we will not be addressing any of the arrear maintenance applications and the enforcement thereof, while one of the parties might be outside the borders of South Africa. So we can start off with saying that we are discussing the enforcement of maintenance orders. And one should note, to start off with as a point of departure, that there should be a maintenance order. So you cannot claim for maintenance and enforcement of a maintenance order if there is no maintenance order in place. If the court has not made a valid court order stating that maintenance should be paid by the respondent. We have cases where I see clients and then they come to my office and they just have a verbal agreement, and now the respondent just simply stopped paying the maintenance, and now they wanted to enforce that. Now that is not what we can do. That is not, we do not have the protection of the Maintenance Act to a large degree in these type of instances. So it's very advisable that you do obtain a valid maintenance order, because that would give you the protection of at least Section 26 and Chapter 5, the civil remedies, as well as the criminality thereof in terms of Section 31. If the respondent then is in arrears. But that is only if you do have a maintenance order. So with other words, people wanting to use this process of warrants of execution, warrants of attachment, the garnishee orders or the emolument attachment orders and so forth, those remedies cannot be used if it's only a verbal agreement. So now we have to look about on specifically Section 24 about what is meant by the effect of orders of maintenance, made by the maintenance court. Now, the Act clearly states in terms of Section 24 that any order or direction made by the maintenance court under the Maintenance Act shall have the same effect as an order in a civil action. So what does that practically mean? That basically means that the court order, the maintenance order, would have the same standing as a normal judgment given by a magistrate in a normal magistrate court. And that is very important, specifically when it comes to enforcement thereof, because if it isn't court order, then quite logically it would mean that if someone is in willful breach thereof, that they are in contempt of a valid court order. If we move on to Section 2, it also states that in terms of Section 16.1, 1A specifically, Section 20 and 21.4, those provisions, if the magistrate makes court orders or judgments in terms of those sections, Section 18 or Section 16, 20 or 21, those orders will be considered to be similar to a civil judgment. Now we're talking about specifically, if you think about Section 16, it is the lying in expenses. If the court makes an order for lying in expenses, now that is expenses that you can claim. You're using the J101 form when you do your first application for lying expenses. Those are already all the expenses that you incurred from the date of birth or even before birth, leading up to the birth, to the time of your application. that you can claim all those expenses back from the respondent. We call that the laying in expenses. So if the court makes an order for laying in expenses, then that is considered to be a court order, and it could be enforced as such. As well as if we look at section 20, it deals with cost orders, specifically to the maintenance service, the service of the documents of the maintenance orders. If the court makes a direction or an order thereof, then that could be also enforced by means of civil execution. As well as in section 21.4, where it deals with the costs of the DNA test. In the event that there is a paternity dispute. If the court makes an order and say that the respondent needs to pay for it and he is in default thereof, then he is in breach of a valid court order, and in enforcement to make him pay for that the cost, for example, for the laying in expenses, or for the cost order if the case so should be, or the DNA cost, that the court could actually enforce that by means of civil execution. Those are just the effects of orders made by the maintenance court. So if we look at the overview of what remedies are available, we guide ourselves to chapter 5 of the Maintenance Act, specifically chapter 26, where it clearly states, and my apologies for the slide that went a little bit over this screen, the enforcement of maintenance or other orders in terms of the Maintenance Act, that's contained in section 26, says whenever any person against whom a maintenance order has been made and he has failed to make such a payment in accordance with that maintenance order, be it monthly or weekly or bi-monthly or whatever the case might be, and against whom any order for payment of a specific sum of money has been made under section 16, 20, or 21, that's not for the laying in expenses or for the DNA test or for the cost order in terms of service, then such order shall be enforceable in respect of any amount which that person has so failed to pay, together with interest thereon. And this is vitally important. You are allowed to claim interest. Now, the Act is not very clear on what amount or the specific amount of maintenance or interest might be claimed. And as a general rule, we use the mora interest, which is published in the Government Gazette. Now, that is usually the same interest amount that a civil court would grant you if someone is in arrears and they give you a judgment against a certain person. Then there's mora interest. That is the prescribed interest rate that has been published in the Government Gazette. So you're entitled to interest. So you're entitled to interest, and the enforcement could be done through either, in terms of sections 26, by execution against property as contemplated in section 27, or the attachment of emoluments, that is, or like what we know in the practice as garnishee orders as contemplated in section 28, or then even the attachment of any debt as contemplated by section 30. So in brief, just as a summary, we turn to section 5. Those are all the statutory provisions that we find in the Maintenance Act dealing specifically with the enforcement of arrear maintenance. And that is the execution against property, the attachment of emoluments or the garnishee order, and then the attachment. There are also other remedies available. Like I mentioned, there is also the possibility that someone could be sequestrated, and we'll deal with all these in a couple of minutes. So sequestration is also an option as an enforcement tool for arrear maintenance. Obviously, there would be contempt of court, which is criminal proceedings in terms of section 31 of the Act, because it is a criminal offense if someone is not paying maintenance. Future maintenance, the attachment of pension funds or provident funds, that is a possible or a possibility as a remedy, as an alternative remedy to what is mentioned in chapter 5 of the Maintenance Acts. But future maintenance, we've dealt with a previous in a previous webinar with Advocate Reuters. If you need access thereto or cannot find that previous webinar, just give me pop me a email and I'll give you those details. So those are the main 6 remedies that could be used. Another one that I've also included is mediation. Now, mediation is not governed by or regulated by the Maintenance Act as such, but I'll address that in a couple of minutes. But that is also a possibility, and there are quite a number of mediators that offer their time and service to different maintenance courts where they go there on a Saturday or during the course of the week, and they do maintenance mediations, and they are quite successful in doing so, specifically when it comes to arrear maintenance and the resolution thereof, as opposed to going through to court and following the civil process, which is quite expensive, or even the criminal route. So mediation we will address definitely in future webinars as well. So if we turn to specifically the three that I mentioned in chapter 5, that is specifically mentioned in the Act. The Act clearly says then, yes, you have three options: the execution against property as contemplated in section 27, or the attachment of emoluments as contemplated in section 28, or the attachment of debts as contemplated in section 30 of the Act. Now, vitally important is that the Act only makes provision that you can choose one of these remedies. What we always say is that, choose your lane. Choose which one you want to have enforced. Would it be the execution against property, or would it be a garnishee order or emolument attachment order, or would it be an attachment of debt as contemplated in section 30? The Act does not allow you to have a warrant of execution against property and an emolument attachment order and an attachment of debt order. You have to choose one of those remedies. Unfortunately, it is still written in the Act, although in the South African Law Reform Commission, in the discussion paper 157, they have made certain recommendations that these portions are actually, they are not helpful at all by only choosing one of these remedies. And the South African Law Reform Commission in their paper 157 recommended that the strict provision of only using one of those three remedies should be eliminated, and that any three of those could be utilized together with certain other remedies such as mediation, but they could be used in conjunction with one another. So in practice, what would happen now, if you do have a garnishee order, for example, and they default on a garnishee order or emolument attachment order, that you have to actually withdraw that matter before you can proceed to ask for a warrant of execution, where they can attach some of his movable or immovable goods to be sold by public auction. So it's a cumbersome process, and it means a dual process, because you have to cancel the one order in order to obtain the other order. It is possible though, but it is usually just a lengthy process, which is quite a cumbersome process and not very conducive and in the spirit of which the Maintenance Act has been written. This is the portion that I'm referring to, like I said, choosing your lane. This is an extract of the J306. That is the document for the enforcement thereof, where you have to mention and you have to mark that you either want one of these three. This is an extract out of the prescribed form. And there you can see they say it is either the authorization for a warrant of execution, or a order for the attachment of emoluments, or for an order for attachment of debt. So you have to mark one of those. Now, I've got a vital problem with this as well, because it is expected from the applicant, the claimant, the one that is on the receiving side of no maintenance, to make a judgment call on which of these three processes should be followed. And for the lay people out there, they do not have the knowledge to know what is the difference between an attachment order, for example, for a debt, or the attachment for immovable or for movable goods. They do not know all these nuances, but yet it is expected of them to make a decision as guidance for the maintenance officer, which they would do. It needs to be mentioned that it is not up to the complainant to drive this whole process, to drive the warrant of execution, or to drive the garnishee order, or the attachment for debt order. It is up to the maintenance officer to see that that is being done. The only responsibility on the respondent or the applicant would be to choose which one do they prefer, because they would know firsthand experience, what is the respondent working? Does he own property in order to make an attachment of goods? Does he have a pension fund for future maintenance? So you have to go to the maintenance officer and tell them that, this is the information that I have, and this is what we can do. Therefore, I would like you to do a warrant of execution or a garnishee order, or whatever the case might be. You also have the other three remedies, and we will briefly be discussing them. Now, this could be used in conjunction with any of the others as well, because these are not prescribed by the Maintenance Act. So you could have the contempt of court, of a court order, the default thereof, criminal proceedings in terms of Section 31. That usually goes hand in hand with the civil enforcement of the maintenance orders as well. But we'll get to talk about some of those in a couple of minutes. So let's start off with the statutory provisions of Section 27. That is the execution against property as contemplated in Section 27. Now, in simple terms, the warrant of execution is a court order that allows the applicant to instruct the sheriff to seize or to judicially attach the respondent's movable property. Now, movable property are things like cars or furniture, stuff that is movable, stuff that is small. It is not a house. That is an immovable property. And then that property needs to be sold by public auction to pay off the arrear maintenance. The rule here is that you still have to issue a warrant of execution only for the movable property, to attach only things like cars and furniture and stuff like that, before you can actually go for and ask the court to entertain a court order for immovable property where property is being sold. So in short, the process there would be that the sheriff of the court would judicially attach the goods. They would go there, they would fill in our inventory, and they would, in layman's terms, they would write up certain things. They would write up the goods that they want to sell. Now, it also must be borne in mind that certain items cannot be attached. Things like stoves and fridges, those are considered necessities, tools of the trade. If he's a tradesman, you cannot take his saw or his paintbrush, or if he's a painter or something like that. Those cannot be judicially attached. So just bear that in mind. But we will be discussing that in future webinars in quite some detail. Also bear in mind that if the value of the goods are above a certain amount, that it needs to be advertised, but that would be a process that the maintenance officer would run on your behalf. Movable property will then be sold by a process of execution or auction publicly, and be sold for cash by the sheriff. That is, in short, what is meant by a warrant of execution. So if you feel that, the respondent, he does have a certain amount of vehicles, or he has furniture, or he has household goods that actually has value, like a TV, a pool table, or whatever, then this might be the route to go. But you have to instruct the maintenance or the maintenance officer that he has certain amount of assets. Now, you can also go back to the J101 form that you initially filled in to see what assets he wrote down, that he stated under oath that he has, and that would give you an indication of what the type of attachable assets that person might have. But like I said, the warrant of execution would be addressed in complete detail, in much more detail, in one of the next webinars, probably the one following this one in 2 weeks' time, where it deals with exactly the steps that needs to be followed, the documents that needs to be filled in by yourself, what documents are needed, for how long is the warrant of execution valid, the stay of warrant of execution if the father disagrees, or the sheriff went and he attached some of the furniture in the house, but it actually belongs to one of the retail stores. What is the process that needs to be followed? How do one deal with that? When could the warrant of execution be suspended? That will be all dealt, because we've got a limited period of time now during this lunch hour. I'm only giving you brief snippets of how it works, but we will be addressing how it works in quite extensive detail, in depth, in a future webinar. So that is basically section 7, what is meant by the execution against property. So now we come to one which is quite a favorite. I quite like that because it works quite well in practice, and that is the attachment of emoluments as contemplated in terms of section 28. Now, we know that in layman's terms as a garnishee order, and that's basically a court order that allows for the attachment of a respondent's salary, his earning, or his wages on a monthly basis in order to cover the arrear payments. So in effect, basically what it means is that the court would order an emolument attachment order, and that would be served on the employer of the respondent. And the employer is then basically placed instead of the debtor with the obligation to deduct certain amount of money per month. And that money must be paid over directly to the complainant on a monthly basis. Now, for the employer, on the employer side, he does have certain obligations. For example, if the respondent leaves his employment, then he needs to inform the court. If he does not do that, if they do not do so, then there are some penalties which might be enforced in terms of the Act as well. But we will be dealing with that in one of the next detailed webinars. One of the things is that the employer may also deduct an amount of 5% as an admin fee of every deduction, and that gets deducted directly from the salary of the respondent and then paid over to you as the complainant. And that could be for arrear maintenance as well, if the court made such an order. So in one of the next Lunch and Learn webinars, we will be discussing the steps that needs to be followed, the documents needed, the evidence that the employer can give regarding the non-payment thereof, how could it be suspended, amended, or even rescinded, as well as the service of the documents. And we will be addressing the issue which we find quite often nowadays is that, you know what, the employer just stop deducting, or they take forever, they take months, even years, in order to effect deductions, and how you can fast track that. But we will be discussing that in quite some detail in one of the next webinars. Now we come to something which is quite unfamiliar. People do not actually know that, and that is the attachment of debt as contemplated in terms of section 30. Now, the court can give you an order that any debt that is owed to the respondent, with other words, the non-paying party, that could be attached by the sheriff. So it's debt owed to the respondent could be attached so that the sheriff could actually take that money, attach that money, and that could be paid over to the complainant. One of the provisions there is that the debt must be owed by a third party to the defaulting party, or the debt must be owed in future, or it must be accruing. And this is sometimes a concept that people do not understand. And it's usually, in order to explain it in quite simple terms. Say, for instance, the respondent has a loan. He loaned out money to a friend or to some of the family. You know what? Let's say an amount of 10,000 rand, and you know that he loaned that amount to the father or the grandfather. And you know that amount, you know that there is the loan account. He gave them the money, and that money will get paid or needs to be paid back at one stage in future. Then you can use the attachment of debt as contemplated in terms of section 30, where you can get a court order to say, but you know what, I know that debt is owed by the grandfather. He still needs to give him 10,000 rand, and then you can have can get a court order so that the sheriff can go to the grant file and actually attach that amount and say, you know what, do not pay that over to the respondent. You have to pay that over to the complainant or the person mentioned in the order as well. We will definitely be discussing this as well in a future webinar to give you more context, give you more detail, the steps that need to be followed, the documents, what types of debt, loan accounts, all those we'll be addressing, you know, what loan accounts payable in the future, how does it work and how is it structured? We will be addressing that in a separate one. But for now, just to give you context on what is meant by a detachment of debt as contemplated in terms of Section 30. Now we come to another one, and now we're entering into those that are not prescribed. Those are not statutory provisions, so it's not governed by the Maintenance Act, but it is normal civil remedies that you could utilize for the payment of arrear maintenance. One of those are sequestrations. Now, sequestrations is not like, don't confuse it with something like castrations where it's snip, snip, although some of the complainants would actually love to do that. But sequestration is basically used when the estate of a person is sequestrated and a liquidator is appointed and then takes control over that person's estate. This is usually done when the person is no longer able to pay his or her debts, which is due to uncontrollable circumstances out of his control, and then it is surrendered. His whole estate is surrendered to the court by means of an order of court and given to a liquidator to manage. Now, this is not very often used in practice because it is an extremely expensive procedure and process, and there's also risk of contribution payable if there's not enough money in the estate to cover all the legal obligations, like paying the fees of the liquidator and so forth. But for now, that will we just say, all right, sequestration is an option, although it's not quite often used in practice. Now we come to future maintenance. We've dealt with this quite extensively in the previous webinar. Like I said, if you need the details thereof, just give me a buzz. I'll give you the link for the previous webinar that dealt with future maintenance. Now, in terms of a recent court case, well, it's not that recent. It was 2006, Soller versus the magistrate Weinberg 2006 case, and that was here in the Western Cape. The court actually held that any pension, annuity, gratuity, compassionate allowance, or even something similar benefits could be attached, notwithstanding any other contrary provision in any law. And that he made mention to Section 26(4) of the Act. So yes, in terms of the Soller case, in terms of the case law up until leading up until now, future maintenance could be claimed. And that's usually pension funds and provident funds. So if you do know that he has a provident fund or a pension fund, then that money will be frozen, and a court order be made that money might be paid over to the guardian's fund if the children are still minors, or whatever the case might be for future maintenance. But we've dealt with future maintenance in a previous webinar, so I'll leave it at that. Mediation, like I said, is also an option. It's becoming quite popular nowadays, and I think it does have quite a lot of value. I've done a couple of maintenance mediations, and with great success, I might add. And it could also be used in arrear maintenance. Now, mediation is basically just a process where there's a neutral person, a neutral intermediary called a mediator that helps the people to reach a mutual satisfactory settlement of the dispute. It is not a court process, so there is no court proceedings involved. It is a voluntary process where the people sit around the table and they discuss the issue of non-payment, and they make a plan, a repayment plan. They come up with ideas, practical ideas that is usually not done in court. So there you could say, you know what, I cannot pay this, but I'll give you that. We can set it off with regards to, I'll give you food instead of money. Or those are the time that creative ideas can flow and can come forward and can be put to the table as an formal alternative of resolving this dispute of arrear maintenance without it going to court. Obviously, it could also be made an order of court, especially when you have new applications. The J214 form could be filled in, the consent order could be filled in. That's an easy process, and then the magistrate can just authorize that, and that could be made an order of court. And this could happen in the normal sense, where mediators go out and they mediate arrear payments as well. And it could be very easily done. My suggestion would be to speak to the local magistrate and see if you can assist them in any shape and form of doing these type of pro bono works. I can just mention that in terms of the paper 157 of the South African Law Reform Commission, they made a couple of recommendations as to the use of mediation as a form of alternative dispute resolution, as an alternative to litigation, in order to relieve the burden of the courts. And it's been done by a number of courts here in the Western Cape, as well as in Gauteng, I believe. And it works brilliantly. Like I said, locally, we are also do mediations at the local court. We have just started, and the responses thereto has been phenomenal. One should also just remember that, you know what, it is not a compulsory process. It's a voluntary process. But in my case, what we do is we ask the magistrate to direct the parties to go for mediation, which is, there's no provision in the Act for that, but at least the parties will attend on a certain date, and then the mediator would have the opportunity to come in, join the parties, and to come to some kind of resolution with regards to arrear maintenance or even new applications which are in dispute. So that could be used, and I foresee that once the amendments to the Maintenance Act has been promulgated in terms of the paper 157 of the Law Reform Commission, that these type of cases would be rife, and that we would see more of these type of cases in future. Obviously, contempt of court, that is also one of the options, and that usually goes hand in hand with the civil execution. If one looks at Section 31 of the Act, it says, you know what, any person who fails to make any particular payment in accordance with a maintenance order shall be guilty of an offence. Remember, guilty of an offence, and liable on conviction to a fine or imprisonment for a period not exceeding 3 years, or such imprisonment without the option of a fine. So these are quite extensive measures. You know what, if the respondent is in arrears, then yes, most definitely he is in contempt of court, in contempt of a court order, and you have the protection of Section 31 of the Maintenance Act. Does it happen in practice? No. Because that would usually mean that the matter needs to be investigated by a prosecutor. It needs to be investigated by the police even, because that's the normal way that a docket goes. So usually the maintenance officer has the responsibility to compile a file and then give it through to the prosecutor, and then they have to decide if they want to prosecute or not. And that's usually where the problem comes in, because the maintenance officers do not have the time to do that, or they do not know how to do that. And then it comes to the prosecutor, and the prosecutor says, but you know what, this is the maintenance matter. It's not a criminal matter, or they don't see it as a criminal matter because, you know what, there was no murder or robbery or whatever. And they do not want to prosecute. And then the complainant is left destitute. And we are working with that. We are giving training for the prosecutors out there, as well as training for the maintenance officers, in order to be forceful to say, but you know what, this is criminal proceedings. And you as the complainant can actually take this further, because it is a criminal offense in terms of Section 31. For not paying maintenance. And we usually use that as a deterrence mechanism. You know what, you should pay maintenance, or you should not fall into arrears, because if you do, then you might go to jail. Do the courts, from the court side, do the courts actually send people to jail? In very exceptional cases, they do. But it is also the view of, and it makes sense, it is also the view of the judiciary that if you jail a father while he has work, then you know what, what's the use thereof? Because if you send him to jail for a certain period of time, then he would not be able to work, and he would not get an income, so then the mother would in any event not get any money. So the courts are reluctant, very reluctant, to give out sentences, and usually, very often, most often, they only give out suspended sentences. In my days, I used to send the people to for correctional supervision. That's also an option, but I would send them for periodic imprisonment, where the when I was magistrate, I would, and they were in arrears, I would jail them. I would tell them that they have to clock in at the local prison on a Friday afternoon, and they will be released on a Monday. And that would happen for a couple of months, for 5 or 6 months, because if they are jailed during, and that's called periodic imprisonment. So if they go to jail for a certain period of time over weekends, then they cannot spend their money on booze or parties or whatever, and then they sit in jail. And very often that was quite a big deterrent. I only sent a couple of those to jail, and then the word started spreading, and the respondent started paying maintenance. Unfortunately, I had discussions with Paulsmoor in the Western Cape, and they simply do not have the capacity to facilitate all these type of defaulters with regards to periodic imprisonment. So unfortunately, this is not happening quite soon in our correctional system, but it is for contempt of court, most definitely, and we do utilize that in conjunction with civil remedies as well. The contempt of court, we will be discussing in a future webinar, give you some context what the state needs to prove, and how you can actually, as a complainant, can assist the maintenance office in compiling a file for criminal prosecution. Like I said, it is being done. Usually when it ends up in criminal proceedings and the respondent then says, you know what, he could not pay because he did not have the means, then they convert that criminal trial to a civil matter, and it gets referred back to the maintenance court for an inquiry, which is just another delay process, which is very infuriating as well. But we will be discussing that in future maintenance or future Lunch and Learn webinars as well. So when is a person considered to be in default? The Act is very prescriptive when it comes to when is a person considered to be in default, and we find that in terms of in section 26(2)(a) of the Act, where it says that the maintenance order must have remained unsatisfied for a period of 10 days from the day on which the relevant amount became due and payable, or that such order was made. So if he had to pay by the last day of every month, then at least 10 working days needs to lapse before you can approach the court in order to get an order for the authorization of a warrant of execution referred to in terms of section 27, or to get a garnishee order in terms of section 28, or to get an attachment order for attachment of debt in terms of section 30. I might just mention, in terms of the garnishee orders, the practice nowadays is that the maintenance officer would inquire right at the beginning with a section 6 inquiry if the respondent is willing to sign voluntarily for a garnishee order, or the court could also make such an order in terms of section 10 for a garnishee order. So even if it's in arrears and you do not have a garnishee order, then you can apply for that. But very often, like we see in practice now, it's become the norm and the practice, is that the emolument attachment order or the garnishee order gets done right in the beginning, and now you only deal with the problems of the employer not deducting, or deducting late, or not paying over, and so forth. But yes, you can only do that if a period of 10 days have lapsed since the money became due and payable, before you can approach the court for these type of remedies. Right, so what do we do? What is the discussion of the process? Obviously, like in all government institutions, there's a process that needs to be followed. One of the processes that you have to do is you have to complete the J306 form. That's a Form K. That is the application for the enforcement of the maintenance order in terms of section 26. Now, this is the civil remedies. Like I said, it's the warrant of execution, it's the emolument attachment order, and the attachment of debt. So you fill in the J306 form. That needs to be done. But together with that, although it is a civil remedy for the recovery thereof, there's also the criminal component. And then you have to fill in the form J470, that is the complaint of failure to comply with a maintenance order for purposes of Section 33. And these two can go hand in hand. I advise my clients to fill in these forms on a monthly basis. So, for instance, here's an arrear 1 month. You know what? Give it 10 days. If he does not pay, then you complete the J306 form and you complete the J470 form. And you do that for every month as in arrears. That is order just to put some pressure on the maintenance office and actually to fast track your matter. What would happen eventually is that once the matter goes to trial, either in the criminal trial or even during the civil remedies process by way of warrant of execution or emolument attachment order or attachment for debt, is that they would combine all those complaints and they would work it out from the beginning, what is the amount that is still in arrears, and they would work on that amount. But for you to, as a complainant, and the suggestion would be, and it's not uncommon that happens on a monthly basis if the respondent is in default. Wait your 10 days, and after that, you can go and file that at the court, at the maintenance officer. This is what the J306 looks like, Form K. There is a short link that you can follow, or there is also a QR code. It is also available in the resource folder tab on the website for those registrants that actually received the link, and they can download it from there. I will make available, it is available, the J306 is available under the resource and templates tab. For those that are just listening on social media, and I see we have a tremendous amount of people listening, also through our website as well. Thank you for that. There is a QR code that you could scan, and that would take you to the DOJ's website, where you would find the J306 form. On the next slide is the J470 form that looks a little bit different because it's now all about the criminal aspect thereof. It's for bringing criminal charges, a complaint for failure to comply with a maintenance order for purposes of Section 31 of the Act. And there's also the short code or the link that you could use, the bit.ly link, or you could use your phone to scan the QR code, and that will take you directly to the website of DOJ where you can download these forms. Or you could simply Google J306 or J470, and Google would bring that up for you to download as well. And my suggestion would be that you fill in these forms beforehand and get all the documents ready. And we will be discussing in the next 3 webinars, we will be discussing what documents do you need to get ready in order to bring to court. To fast track your application form, because there's no use you go there to report within the 10 days period of time that is in arrears, but you do not bring any documentation. You don't have your proof. You don't have the substantiating documentation validating your claim. Then you will be sent back and you have to go back there as well. So my suggestion would be listen to the next 3 webinars. We will be discussing that. But in the meanwhile, if the respondent is in arrears, download these forms beforehand so that you know and familiarize yourself with the content thereof, that you know what needs to be filled in. But we will be discussing that in the next webinars. Right, now we come to the last portion before we adjourn and go forward with our afternoon tasks, is the valid defense for arrear maintenance. Now, this is also a thing that has been debated all the ways. And in Section 31(2) of the Maintenance Act, it says that, if a defense is raised in any prosecution for any offense under this section, that any failure of payment of maintenance was done due to lack of means of the party or the respondent that has been charged with that crime, then that should be a valid defense, unless it is proven that the conduct was due to his own doing. So if he lost his job out of his own accord because he was sleeping at the work or whatever, that would be considered to be his own misconduct, due to his own misconduct, and the court would not entertain that. But yes, the biggest offense that anyone could have in terms of the criminal prosecution, and most definitely, surely, like we see in terms of the means test to see does he have the means to pay maintenance in the civil side, the lack of means would most definitely be a valid offense for arrear maintenance. So if you go to court, let me just put it in practical terms, if you go to court and the respondent, he's then the accused, might say that, you know what, he could not pay due to lack of means, then the state needs to prove certain things. And we'll be discussing that as well. But yes, most definitely, it is considered to be a valid offense in terms of the South African law, that due to lack of means, he could be excused for not paying the arrear maintenance. But like I said, we will be addressing that in quite some detail in future webinars, because most people deal with these type of matters on a daily basis. And that basically brings us to the end of our Lunch and Learn webinar for today, which was proudly presented by myself. I'm Eugene Opperman. I'm a legal practitioner, practicing family law for the past 23 years, specializing mostly in maintenance matters. Like you can see, I'm very passionate about it. Domestic violence as well as any matters pertaining to children's rights. And I also do a lot of mediation on all of these matters. I would like to thank Erin O'Neill for the compilation of the handout. Thank you to her as well. And I would love you guys to join us on the next webinars, the next 3 webinars. We will be dealing with the Chapter 5 remedies, the warrant of execution, the warrant of attachment for emoluments, as well as the attachment for debts. We will get into so much detail and make you enthusiastic about actually claiming arrear maintenance. Thank you for joining us, and enjoy your weekend further. Just on a side note, just to remind the people that we will be doing, the Advocate Raters and myself will be doing and unpacking the Domestic Violence Act, which has been amended on the 14th of this month, of April. And we will be addressing all those issues. What are the changes? How does it affect us? Make it practical on how does it really affect the people at large. You're most welcome to join us on the 6th of May. It could be in person in Cape Town at the NPA Auditorium, starting at 9 o'clock up until 2 o'clock, or you could join us online as well. And the registrations could be done on by the other websites, on the Lunch and Learn website or the Child Maintenance website as well. Thank you so much for joining us. That is basically all that we have time for today. It was great as always, and we'll be seeing you next week, same time, same place. Enjoy your weekend, I've got a weekend now because I worked enough. So yeah, I'm basically taking some time off. But I'll be ready next week, same time, same place, for the Lunch and Learn webinars. Have a fantastic afternoon further.